This is Law Bytes, a podcast with Michael Geist.
How to boost artificial intelligence whilst protecting citizens' rights. That's the question the European Commission is hoping to answer, as it unveiled the world's first plans to regulate how the technology is used on Wednesday. The proposed rules aim to curb high-risk uses of AI, like biometric identification, which includes facial recognition, or an outright ban on things like government-conducted social scoring, which China already uses, to measure an individual's trustworthiness.
Last week, the European Commission launched what promises to be a global multi-year debate on the regulation of artificial intelligence. Several years in development, the proposed rules would ban some uses of AI, regulate others, and establish significant penalties for those that fail to abide by the rules. European leaders believe the initiative will place them at the forefront of AI, borrowing from the data protection privacy strategy of seeking to export EU solutions to the rest of the world. Céline Castets-Renard is a colleague at the University of Ottawa, where she holds the University Research Chair on Accountable Artificial Intelligence in a Global World. She joins me on the podcast to discuss the EU plans, their implications for Canadian AI policy, and the road ahead for the regulation of artificial intelligence. Céline, thanks so much for joining me on the podcast.
Thank you, Michael. It's my pleasure.
Okay, I'm really glad that you take time out to come and join me this week. On a week when the European Commission released what it has termed the first ever legal framework on artificial intelligence, AI, and it believes that it positions Europe to play a leading role globally. For those that are hearing about this for the first time, can you give us a bit of background? Where did it come from? How long has it been in the works, and what kind of consultation process was involved as they developed these rules?
Indeed, the European Commission published 2 days ago new rules and actions included in 3 different texts. The first one is the proposal for regulation on AI. I will tell you more later. The second is a new coordinated plan with member states. This plan will outline the necessary policy changes and investments at member states level towards a European leading position. Actually, in a global policy context where more and more countries, such as Canada, are investing heavily in AI, the EU urges member states to act together to exploit the opportunities and to join their investments. For instance, one of the goals is to build a strategic leadership in high-impact sectors such as climate and environment, health, or robotics. And finally, the third text is a new regulation which will replace a 2006 directive on machinery products. This regulation will cover an extensive range of consumer and professional products, including robots, 3D printers, construction machines, industrial production lines. This new machinery regulation will ensure that the new generation of machinery guarantees the safety of users and consumers and encourages innovation. While the AI regulation will address the safety risk of AI systems, the new machine regulation will ensure the safe integration of the AI system into the overall machinery. Of course, the most interesting part of this legal framework is the AI regulation. Where did this come from? The first step was the publication of the European AI strategy in 2018 under the former European Commission chaired by Juncker. The AI-level expert group on AI also developed guidelines for trustworthy AI in 2019 and also an assessment list for trustworthy AI in 2020. These guidelines were ethical principles, but the expert group was already calling for the development of a legal framework. Then, under the new presidency of Ursula von der Leyen, the European Commission continued its works by publishing a white paper in February 2020 in which it set out its vision for AI in Europe, so-called an ecosystem of excellence and trust, announcing the rules published 2 days ago. So finally, 3 years have therefore passed between the publication of the strategy and the proposed regulation.
Okay, so a pretty long process, and I mean it's even more complicated as you point out the various elements that they're focusing on, including machinery, than I think some of the initial press reports have led many to believe. The emphasis has certainly been on the AI side. I know that there was a leak of at least a slightly earlier version just a few days before. So groups in some ways had an opportunity to prepare for this, or at least prepare their initial reaction. It's only been a couple of days, but what was the initial reaction, say from civil society groups, perhaps on the one side, who have been advocating for a long time on some of these AI issues, as well as, of course, the tech companies who will be directly affected by some of these rules?
Yes, as it is often the case with social impact technologies, there is a strong divide between representatives of civil society and the companies that wish to develop them. Technology companies complain about not being able to innovate. It's a very usual argument. However, measures in favor of innovation have been taken that concern small companies and startups. Also, AI regulatory sandboxes will allow the development of innovative AI systems. On the other hand, we can also see that the civil society and the advocacy groups consider that the protection of fundamental rights does not go far enough. Nevertheless, we can note, for instance, that the material scope of application is broad and includes machine learning, as well as expert systems or statistical approaches, which will easily allow to include all automated decision systems, in particular those used by the governments. I think this point is very important because no proof in relation with the kind of system used would be probably necessary. And as usual, we had a lot of public consultation and especially a public consultation on the AI white paper was initiated between February and June. Most 1,250 contributions are made online thanks to an online survey, and most contribution came from the EU member states, but also outside of the EU. And also 450 position papers were submitted during the consultation. And of course, the lobbying groups are still working hardly right now to influence the European Parliament members. So I think we cannot say that there is no consultation on this paper.
So there was a fair amount of consultation, and unsurprisingly, of course, as you suggest, there's a bit of a divide between some of the civil society groups and technology companies, with many things centering around innovation and the like. Now, I know that the rules prohibit several AI uses, and that's been, I think, one of the major focal points for civil society. Can you describe what the areas where there's simply prohibitions are?
Yes, sure. As you mentioned, some rules some AI system or some use of AI systems are prohibited because the AI regulation follow a risk-based approach, and the European Commission considers that some risks are unacceptable, and that is the reason why some practices and some uses are prohibited. And especially if the use could generate a stress to people's safety, livelihoods, or their rights. And more specifically, these are systems or applications that manipulate human behavior to circumvent circumvent the free will of users. For example, the use of voice assistants to encourage dangerous behavior by children. This is also the case for the use of an AI system that exploits the vulnerabilities of specific groups of people because of their age or physical or mental disability in order to manipulate their behavior. This kind of use is also prohibited, and are also targeted the systems that enable social scoring by governments, only by governments. And finally, the use of real-time remote biometric identification systems in publicly accessible spaces for the purpose of law enforcement is prohibited, but there are some exceptions, and I'm going to talk about it later.
Okay, so it covers health, safety. I mean, it's very interesting to see rules specifically focused on the kind of manipulation concerns that I think many people have raised when they think about AI. You did mention the biometric mass surveillance in public spaces, and I know that was one that some groups were looking for simply an outright ban. You suggested that there are some exceptions. Can you describe what those are?
Yes, many groups would like a ban on it. And but firstly, I would like to point out that the text does not mention the facial recognition technology, what may be surprising. It is, however, covered by the expression remote biometric identification systems, which means an AI system for the purpose of identifying natural persons at a distance through the comparison of a person biometrics data with the biometric data contained in a reference database and without prior knowledge of the user of the AI system, whether the person will be present and can be identified. This is the definition of the AI regulation, and this is exactly how a facial recognition system works. So the word is not used, and I think it's symbolic. And regarding the regime, it is true that the debate of the use of facial recognition has emerged since the white paper in February 2020, which did not contain such a ban, while earlier drafts were more ambitious. Finally, member states requested strongly the authorization to use this technology in favor of law enforcement, and that is the reason why we have two different rules to regulate facial recognition. The first regime concerned the use of real-time remote biometric identification system in publicly accessible spaces for the purpose of law enforcement. And this use is in principle prohibited. But nevertheless, it will be authorized by exception strictly necessary for three specific objectives. The first one is the search for victims of crime, including missing children. The second objective is the prevention of a specific and imminent terrorist threat. And the third is the detection, location, identification of prosecution of perpetrator or suspect of a serious criminal offense strictly listed, such as terrorism, trafficking in human beings, sexual exploitation of children. But in this last case, 32 crimes are listed, including economic crimes such as fraud or corruption, which ultimately makes the exceptions broader than they appear. And however, it should be noted that these exceptions are governed by safeguards and conditions in relation to the use, in particular as regards the temporal, geographic, and personal limitations. Moreover, such use is subject to authorization by a judicial or other independent body and to appropriate limits in time, geographic reach, and the databases searched. So maybe it's a compromise between the law enforcement issues and the fundamental rights. And in the other cases, all remote biometric identification systems are considered high risk and subject to strict requirements.
Okay, that's interesting. So the notion that member states were looking for an exception, and once you start including all the various kind of crimes or circumstances under which this may be permissible, admittedly with some of the safeguards you're describing, it sounds as if we're going to see those technologies implemented in public spaces, and it's going to be more about the safeguards, the authorizations, and the like, as opposed to simply an outright ban. Those are some of the prohibited uses. And there's one, of course, with the mass surveillance that isn't quite prohibited, but there are some safeguards around it. I know that the rules also seek to establish limitations and safeguards similarly on a whole series of other AI uses, covering just about everything from self-driving cars to exam scoring. AI, of course, is so prevalent now and increasingly prevalent in society. How do the rules seek to establish some kind of limits or safeguards on that kind of almost everyday use of artificial intelligence?
Yes, that is a very interesting point of this regulation, and that is the most important part. Because many, as you mentioned, Michael, many AI systems are already used and could be risky and could have a high risk. And that is, for instance, the case with critical infrastructures such as transport, safety components of products, employment, workers management, for instance, with CV13 safe to work for recruitment procedures. It could also concern essential private and public services, such as credit scoring, denying citizens opportunity to obtain a loan, and the law of enforcement and migration and administration of justice, and so on. And so, because this kind of use this kind of AI systems could be a high-risk AI system, strict obligation has to be fulfilled. For instance, a risk management system should be established and consist of a continuous iterative process run throughout the entire life cycle of a high-risk AI system, requiring regular systematic updating in order to mitigate the risk. And also, high quality of the data sets has to feed the system, and in order to minimize the risk and discriminatory outcomes. And appropriate data governance should also take into account possible biases, and the data sets should be relevant and representative. We can also mention that technical documentation should be drawn up before that system is placed on the market and be kept up to date. And this detailed documentation provides all information necessary on the system and its purpose for authorities to assess its compliance. We can also mention the automatic recording of activity while the AI system is operating has to be designed and to ensure traceability of results. And finally, clear and adequate information to the users has to be provided, as well as an appropriate human oversight and a high level of robustness, security, and accuracy. And I think that the proposed minimum requirements are already state-of-the-art for many diligent operators. And they are also the result of 2 years of preparatory work. So I think it doesn't come as a surprise today.
Okay, so not a surprise, but interesting to see the emphasis on transparency, greater disclosure, really trying to take something that I think for many has been hidden in the background. People don't really see the AI, often don't even appreciate that it's there, and trying to put it much more in the foreground so that there's awareness and hopefully for many a better understanding of what's taking place. Now, this quite clearly touches such a wide range of activities. I mean, as we've been talking about, everything from law enforcement on the one hand to everyday products, machinery, and of course, so many different day-to-day services, even where AI has come to have a role. I guess it begs the question: how does Europe propose to enforce these rules? Is there an oversight body? Are there penalties for failure to abide by what's being set out?
Yes, sure, and that is an important question. And the Commission proposes to enforce the regulation by establishing national competent authorities designated by each member state. And these authorities ensure the application and will ensure the application and implementation of the regulation. Also, a new artificial intelligence board would be created to contribute to the effective cooperation of the national supervisory authorities. And one can observe that this is exactly the same model as the GDPR, and that is an usual model in digital law in several topics and several fields. And the penalties are very high and can go up to 30 millions of euros, or if the offender is a company, up to 6% of its total worldwide annual turnover for the precedent financial year, whichever is higher, in case of non-compliance with the prohibition of the AI practices. Other smaller penalties are stated for less important compliance cases. And finally, these penalties are higher than the GDPR states the penalties in data protection.
Yeah, they are. They're very high. I was just sort of thinking to myself, for a company that engages both in AI and in some of the data-related issues, there's often, of course, a bit of a correlation. Violating those twin set of rules could lead to handing over a sizable proportion of their global revenues, at least as a threat from a penalty perspective. You mentioned data protection, and there quite clearly some obvious analogies there. Certainly, one would be the penalties that are associated with it. I'm wondering if there are similar analogies with respect to the ability to file complaints by an individual. And of course, that's been an important part of regimes that we've seen around the world on data protection, the ability for individuals to file complaints with the relevant authority, whether a data protection commissioner or in Canada, a privacy commissioner. Is there a similar kind of complaints mechanism under this system?
I have to say that that is not the case because there is no specific rights for the people to whom the systems are used, and neither a complaint mechanism. And this could be considered as a weakness of the text. However, we should consider the fact that high risk generated by AI systems are analyzed in consideration of the fundamental rights protected by the EU Charter of Fundamental Rights. And also several provisions concern the risk of biases and discrimination. And also, of course, the victims have a right to judicial redress. And moreover, nothing prevents member states from providing for a system of complaints to the national supervisory authorities, which could be set up on the model of the personal data protection authorities. When we consider the mission of these authorities, this mission is not specified in the regulation, which leaves room for the member states in this point.
Okay, so there's nothing specific here, sort of Europe-wide, in terms of establishing that kind of complaints-based mechanism, but it's open to individual countries to do so. I was also curious about the jurisdictional limits of the rules. Sitting here in Canada right now, looking at what's taking place, the Canadian government continues to focus on AI for Canada, and the recent budget included more money to emphasize a national AI strategy for those resulting Canadian companies focused on AI. I mean, I'm sure they're paying attention to the rules, but to what extent would European AI rules directly affect Canadian companies or any other companies or organizations located outside of the EU?
That is a very important question, and as you mentioned, of course, many companies are very focused on this regulation, and I think they're not very satisfied by this regulation, and the territorial scope is very broad, as the regulation applies to providers placing on the market or putting into service AI systems in the union, irrespective of whether those providers are established within the union or in a third country. So Canadian AI companies would be subject to this rule, to this AI regulation, if they sold AI products into Europe.
So very broad approach. I mean, again, reminiscent, I think, of the approach on data protection, which has clearly had a significant influence globally, and companies around the world pay close attention and often seek to comply with those EU rules. You know, I mentioned Canada a moment ago, and taking a look at what we see in Europe and seeing the ongoing emphasis around AI in Canada, can't help but think, where do we stand in Canada from an AI regulation perspective? Obviously, the government's been focused on building up our capabilities, trying to develop a leadership position in AI. Where are we at in terms of some of the same kinds of rules that we've just seen introduced within Europe?
That's an interesting question as well, and I was wondering if it could have an impact in Canada, but I don't know. It is always difficult to import a legal model from one part of the world to another part of the world, while the legal systems are different, and it is even often utopian. As the law is a part of culture, history, context, and of course, political will. And Canada could be influenced by Europe, but also by the United States. So one may think that Canada will not want to go as far as Europe, or will want to do it differently. For the moment, the human-centered ethical principles, for instance, in the Montreal Declaration or Toronto Declaration, and also the soft law as a Treasury Board directive on automated decision making are preferred. However, as Canada has invested heavily in AI and continues to do so, it is probably time to secure the stakeholders by setting clear and legal rules, as well as creating a real responsibility of the chain of actors, as evoked by the Digital Charter. In any case, we can invite the government of Canada to do so, in my opinion.
Okay, so there's a lot of work to be done. There's been, little hints, I guess, of where Canada may go, but to the extent to which Europe's obviously now introduced these rules, those looking for similar kinds of rules in Canada have a bit of a road ahead. Speaking of a road ahead, why don't we end with this? I mean, obviously, this is really fresh in Europe, and people are still digesting what's been proposed and some of the implications. What's the process that lies ahead? When might we expect to see this passed? How many more hoops, I suppose, does this have to jump through before there's the prospect of this becoming enforceable regulations?
Indeed, this is only the first step in a long legislative process. The European Parliament will be able to debate and modify the text and has to adopt it. At the same time, or just after, the Council of the European Union must also adopt it. And it is to be hoped that these three bodies, contributing together to the creation of European law, can agree on the same text. If this is not the case, a compromise must be found in a trialogue between the European Commission, the European Parliament, and the Council of the EU. And this trialogue has to adopt the same text. And this process is likely to take 2 or 3 years. And we can hope that it will go all the way, and that it will be faster than the GDPR, which took 4 years to be adopted. And finally, the text will enter into force only 2 years after its publication on the official journal of the EU. This delay is usual to allow stakeholders to organize their compliance. So we can see that this text is not for tomorrow, but it's still a significant step forward for the legal and not only ethical framework of AI in Europe.
Okay, so a long road ahead when it comes to this, both in terms of getting it passed through the various chambers, and then even after that, a significant period of time before it actually gets implemented. But as you suggest, given that this is really the first of its kind, I think in some ways marks a real turning point for AI regulation on a global level. And one would imagine that other countries are paying close attention, and this feels like the beginning of a long global debate around AI regulation. And so it's so important to I think to be paying attention. Céline, thank you so much for walking us through where things are at right now and what lies ahead. Thanks so much for joining me on the podcast.
Thank you for having me, Michael. My pleasure.
That's the Law Bytes podcast for this week. If you have comments, suggestions, or other feedback, write to lawbytes@pobox.com. Follow the podcast on Twitter @LawBytesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bytes podcast is produced by Gerardo Lebrun Laboy. Music by the Laboy brothers, Gerardo and Jose Lebrun Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.